All right, give it another couple seconds. All right, let's begin. All right, so good morning, good afternoon all. Thank you for joining us in today's webinar entitled Rules and Regulations Regarding Capital Raising in Japan. My name is Koji Yamamoto. I'm an investment partner from our Tokyo office of Withers, and I'm here joined by my colleague, Omori-sensei. Hello. So first of all, I know it's Wednesday, it's in the middle of the afternoon. I just want to say, I'm quite happy that so many of you could join us today. We did see the list. I was quite happy to see a lot of familiar names in that list and a lot of my old drinking buddies. So I want to just give a special shout out to all of my friends who decided to, I hope, support me as opposed to troll me for this webinar. So before we get started, I'd like to briefly go over some housekeeping notes. First of all, please note all the attendees have been muted by default. So before joining the session, and your video function has been turned off as well. And if you have any questions pertaining to any of the materials covered in this presentation, please type your questions in the Q&A box. I think it's somewhere in your functionality, and we're going to try to answer them in the last 15 minutes of this presentation. So just jumping right into this. All right, so I guess, just before we just jump into the actual meeting, we just thought to give a brief market trend and overview. I think, elephant in the room, we definitely do live in, I guess for lack of a better word, crazy times now. COVID has definitely had a disruption to, I think, everything in business as we know it. And I guess from our perspective, we would definitely say capital, it has a huge impact on capital raising here in Japan with COVID. First of all, just the travel restrictions, if people can't come to Japan anymore, people can't leave Japan. And this is, from the ability to do due diligence, to check out, just meet the managers, to fly into Japan. All of this had what we viewed quite a very, very strong and negative impact on the ability of a lot of our clients and offshore fund managers to raise capital in Japan. On the flip side, we have seen those fund managers that have offices in Japan in certain capacities. Obviously they weren't as negatively impacted by the travel restrictions, but at the same time there too, I don't think it'd be fair to say that they weren't unaffected too. The fact of the matter is here in Japan, it's always hard to tell with the numbers right now with COVID, how excited or how concerned you should be. But the fact is, even now, in-person meetings are rare. So even those people who have offices in Japan, I strongly suspect it's not that easy to just pop over to, to an investor and just have an face-to-face meeting. So let's say we would definitely say that things have changed. We are now living in a kind of a post-COVID world right now. And so things have definitely changed. But at the same time, we are still seeing some movement in the market. We've been seeing some hot spots where obviously, even though the markets are defying logic and seem to be just going up, but at the same time, we're seeing fixed income credit products. They appear to be doing quite well right now. And aside from that, we're also seeing a lot of activism. The type funds, they were getting quite hot prior to COVID. But even now, we are definitely seeing a lot of activist funds being formed. And we're also quite aware of activist managers who are creating Japan offices to work with the Japan listed companies here. So, I think it'd be untruthful for me to say on any level that it's business as usual here in Japan. But at the same time, we do believe that there are some sweet spots, there are things still happening, and deals are being done. So it's kind of a mixed bag, but I don't want to kind of go into some denial of reality and say, hey, everything's going to be fine. All right, and so with that, we want to do a brief update before we just really jump into the presentation. So today's presentation, time permitting, will really be based on just 4 quick topics. The first one is obviously going to be probably the most key topic. It's really an overview of the Japanese regulatory regime regarding securities distribution or cap raising. I'm going to add that to that. Topic number 2 would be if you decide to set up in Japan, which albeit it will be quite difficult right now. Number 3, well, what can I do in Japan if I don't have a license? What am I allowed to do? And topic number 4, well, listen, we do want to set up in Japan. We want to get a license. We want to do things. How do we do that? So those will be the 4 main topics. of today's discussion. All right, so moving to the key or the meat of today's topic is really an overview of the financial regulatory regime here in Tokyo. No, I apologize, in Japan. I've done this quite often, and I just think the key thing to understand is there are 4 registrations here in Japan. There's some sub-registrations, but the key thing to note is that there's 4. And to understand the 4 registrations, we also have to talk about securities. But first of all, let's talk about the 4 registrations. The first one is called the Type 1 Financial Instruments Dealers Registration. The second one is the Type 2 Financial Instruments Dealers Registration. The third one is the Discretionary Investment Management Registration. And the fourth one is Investment Advisory Registration. Now, to understand these 4 registrations, first of all, it's really important to understand that in Japan, all types of securities, like fund interests, are classified in 2 specific types. First of all, you would have something called what we call the paragraph 1 securities. These would be shares of capital stock company, bonds, warrants, what generally you would see as liquid, with high transferability. And in terms of the fund space, Cayman exempted companies, Cayman unit trusts, any type of corporate or trust type funds are generally deemed as paragraph 1 securities. And to market paragraph 1 securities in Japan, you would need the type 1 dealer. So type 1 dealer allows you to market paragraph 1 securities. Paragraph 2 securities. Paragraph 2 securities are more the illiquid type of securities. And generally there will be trust certificates, not unit trusts, but trust certificates of domestic trusts, LLC interests. So generally in the fund space, we would really see, truthfully, the real paragraph 2 security that we would see is a limited partnership, whether it's Cayman, Delaware, wherever it may be, it would be the limited partnership. So in other words, to market a paragraph 2 security in Japan, you would need a type 2 license. So in other words, type 1 license allows you to market paragraph 1 securities, type 2 license allows you to market paragraph 2 securities. Now, we always get asked this question a lot, and even though there's always this kind of link between strategy and the type of fund, we do want to be quite clear. For the Japan law classification, there's absolutely no reference to the strategy itself. So in other words, as a default matter, if a Cayman corporate exempted fund, the shares would be deemed as paragraph 1 securities. There is no regard to whether that Cayman fund is a closed-ended, it's limited, if it's invested in real estate, they don't look at that. The only key thing is they look at the legal entity, and based on that legal entity, without any regard to the actual strategy, it's either deemed as a paragraph 1 security or a paragraph 2 security. And so before I go on that, I'm also going to go through the other 2 licenses because it's quite important, is the Discretionary Investment Management License and the Investment Advisory License. The Discretionary Investment Management License, this is quite key to know because I think it's the same in Hong Kong, but in Japan, they actually divide to the 2 business activities of managing money versus giving investment advice. So the Discretionary Investment Management Business License, it allows you to manage Japanese money. The Investment Advisory and Agency License, it allows you to give investment advice regarding the sale or purchase of a security. So those are the 4 licenses, and everything has to fit within those 4, or it's just unregistered business activity. All right, so now that we just did a brief overview of the 4 registrations, I think it's important to talk, well, how does this really apply? Like, which license do I need? And to answer this question, it really goes to the question of, how do you really intend to raise capital in Japan? And this, which is also probably tied to who are your target investors. So in Japan, broadly, we would call the 2 ways of capital raising as the first way would be the distribution model, and the second way is the management model. We call them either direct capital raising versus indirect capital raising. So the distribution model, this is the one that I suspect that most people are quite familiar. This is the entire model whereby you would directly sell interests of your fund to Japanese investors. So this is where you would either hire a type 1 dealer or a type 2 dealer or use some kind of exemption and just approach Japanese investors and go, please buy interests in my fund. This is the one that we would typically see we would use with banks, insurance companies, and corporations. But we're going to talk about this a bit more, but you don't see it with pension funds, right? So this entire thing is distribution model of direct capital raising. This is where you're directly selling interests of your fund to Japanese investors. Now, the second model, or the management model, or the indirect capital raising, this one is, I don't know if I would be accurate to call it as new, but it is definitely a model that became quite popular about five or 6 years ago. And this has really started with GPIF. And GPIF is one of the largest, probably one of the world's largest pension funds. But this is when they said, listen, we would like to have a direct relationship with our foreign investment management partners. And so this brought up this entire surge of people looking at the indirect capital raise model. What is this model? This model is, instead of getting a distribution license, so you wouldn't get a type 1, you wouldn't get a type 2. Instead, you would get the discretionary investment management license. And under this license, instead of selling interests of your fund into Japan, what you would do is seek to enter into investment management mandates with Japan clients. So, and then once you get that mandate, you would, under that authority that you have as an investment manager or a gatekeeper or whatever expression you want to use, you would then invest that money into an affiliated fund. So at the end of the day, it's kind of the same thing. Japanese money going into one of your funds, but the model is quite different. In one model, you are acting as a distributor, or you're having a distributor do it. In the second model, you are acting as the Japan gatekeeper. You are the one who are making discretions where you would invest that money into an affiliated fund. And so why would you use the second model? Why it's so popular? And to answer this question, it's actually a very, very different topic about understanding how Japanese pension funds work. As a general matter, Japanese pension funds do not have the ability to make their own investment decisions. Yes, I know there's one or two outliers out there, but the fact is, as a general matter, Japanese pension funds do not make their own investment decisions. In other words, Japanese pension funds must team up with the gatekeeper anyways. So a Japanese pension fund would give investment management authority to a gatekeeper or a DIM, and then they would invest into an offshore fund. So this entire idea of this management of the indirect capital raising is where, instead of the traditional gatekeepers that you would see for the Japanese pension funds like Sumitomo, Mitsubishi, the usual players, it's the idea of the foreign asset manager, by having their Japan office take that role as the gatekeeper of the Japanese pension fund. And like I said, this all really started about couple of years ago. It's really started with GPIF. Since then, I know I can talk about it because it's public, like people like, the big one was Legal in General, Naveen. We've seen AQR came but the left. Like a lot of companies, just came into Japan with this model because they all had strong ties with Japanese pension funds, or they had a business model that they thought was very, very attractive to Japanese pension funds. So when you look at these two different models, which type of model do I want? Because the licenses are very different. The type 1, the type 2 for the distribution versus a DIM license for the indirect management model. These are totally different licenses. So we would always talk about who are your target clients? Because I can guarantee to you, you do not need this DIM license if you're going to be targeting banks and insurance companies. They don't need that. They don't need a gatekeeper. They'll just come in directly. So that's one of the key things that I do want to stress right now is when you want to come to Japan, who are your target clients? Because that will change which model that you'll be looking for. All right. So especially now, this is a very, very good topic point. We've talked about the registrations and the models, but the exemptions. What about these ways that, well, not too sure if I really want to go all in Japan and get these registrations. I've heard all these stories about the regulators, yada, yada, yada. What other ways are there to do that? And so what we're going to do now is briefly cover 2 exemptions. There are other exemptions out there, but we're just going to cover 2. So the first default rule, again, is to market a paragraph 1 or paragraph 2 securities, you have to be a type 1 dealer or a type 2 dealer. Now, there is one specific exemption that we've seen, I guess, limited use. It's getting probably a lot more popular now, is under Article 58.2 of the FIA, a foreign securities firm may market securities to Japan investors without any type 1 license or type 2 license subject to certain conditions being met based on the type of investor. So just to be clear again, if you are a foreign securities firm, where you don't need the type 1 license, you don't need the type 2 license, you may market your fund interest to Japanese investors as long as you meet certain requirements. Now, I want to be quite clear, that sounds great, but it's not that easy as you would think. So first of all, let's talk about what kind of Japanese investors you can use this entire foreign securities firm exemption. It's actually quite broad. It includes the more traditional players and the people that I suspect most people on this webinar who are interested, the banks, the insurance companies, the DIMs. These are the people that you can market to. But what are the limitations on this? Well, number one, you have to be a foreign securities firm. And what is this entire definition of foreign securities firm? It's a fairly debated topic, but just strictly legally speaking, if you are licensed or registered or permitted to engage in the offering of securities in your home jurisdiction, so if you're like, I think it's a type 1 in the Hong Kong, or if you're a broker-dealer in the US, you would definitely qualify to be allowed to, you would be deemed as a foreign securities firm exemption, foreign securities firm. So that's number one. You have to be a foreign securities firm. But I'm going to be quite candid now. We are aware some people are taking on very expansive views on the definition of what a sort of foreign securities firm is. Some people are using the safe harbor in the US and go, well, I'm not a broker-dealer in the US, but I can use safe harbor and I can market under the safe harbor exemption in the US. Am I a foreign securities firm? So we do know. It's being discussed. Some people are pushing the limits, but number one, you have to be a foreign securities firm. The second thing, and this is the second one that kind of we thought was problematic for a lot of our clients who sought to use this, was if you're using the foreign securities firm exemption, you are not permitted to engage in marketing activities in Japan. So I want to repeat that because it's quite important. So listen, you are not allowed to engage in marketing activities in Japan. So what can you do? Sure, you can make phone calls, you can send emails, you can do all that stuff. That is fine. If you jump on a plane, come in with some PPMs, and then you start visiting Japanese people while physically in Japan, that is actually a breach of the foreign securities firm exemption. So it's one of those things. You know, we've seen some people use it quite successfully. You know, they ask the Japan investor to come to the manager shop, and it's one of those things. It's there, it's usable, and probably if anything, it's quite usable now with the COVID, with all the travel restrictions. But historically we had heard. And I suspect a lot of people on this webinar are much more better to talk about it than myself, but we are aware that a lot of some managers had found the inability to come into Japan to be too restrictive. Now, at the same time, before I move on to the next topic, we are aware a lot of people are getting very creative on this. They use a lot of hybrid theories about, you know, well, I'm in Japan, I don't do marketing, I do reverse solicitation, yada, yada. We know that there's a lot of theories out there. You know, if you have questions, we can go through this because that'd be a topic in itself. But the fact of the matter is the foreign securities firm exemption has been very, very popular, particularly for those who are looking to sell paragraph 1 products. Type 2 dealers, we're going to talk about the Article 63 exemption anyways, but it's the type 1, paragraph 1 products we've seen the foreign securities firm being used quite commonly. All right, turning to the next one. The second exemption is the famous or infamous, the Article 63 exemption. And, you know, this is an exemption that we get asked about all the time, and I could just talk about this for hours and hours. It seems quite simple, but it's not really. But the first thing I'm going to even, before I talk about it, the Article 63 exemption, it only applies to the limited partnerships. All right, so if you have any corporate funds, trust funds, you could pretty much zone out on this part of this discussion unless you're going to create an LP feeder fund. This Article 63 only applies to limited partnerships. So I'm going to start off the conversation right there. Okay, so now what is Article 63? Article 63 exemption is a specific exemption that applies to the general partner of an LP fund. Again, only an LP fund. And it allows to do the general partner to do 2 things that would typically require a license. Number one, it allows the general partner to engage in self-offering. Self-offering is just marketing your own fund. So this would allow the general partner to come into Japan with a PPM, pitch book, whatever, and go, please buy my fund, please buy my fund. Typically, as limited partnership interests are paragraph 2 securities, and they would need a type 2 license, the general partner would need a type 2 license. But Article 63 is an exemption from that. If the general partner files Article 63, they don't need a type 2 license. The second aspect of the Article 63 exemption that is very commonly missed, and even to this day, it seems people keep forgetting about this, but it's self-management. And this is this entire concept, and I wish I had more time to explain this because it's just a tricky concept to understand in one go. But with respect to limited partnership funds, doesn't matter how the Japan investor got in their type 2 Article 63, it doesn't matter. Instead, you have a limited partnership fund and you have a Japanese investor, a Japanese LP in a limited partnership fund. As a matter of default, the general partner is deemed to be providing investment management services to that Japanese limited partner, right? Matter of default, the limited partnership fund came in, it doesn't matter where, if you were one Japanese investor, the GP is providing management services to that limited partner. And as discussed, providing management services to a Japanese investor, that requires the DIM license, right? So Article 63, it allows the general partner to engage in self-management activities without being registered as a DIM. So Article 63, it covers two things. Market your fund without the type 2 license, and when you have a Japan investor in your fund, it allows you to manage that money without having the DIM license. So it's two things, and I really want to stress, for some reason, people just keep focusing on the good side, on the marketing side, and they forget to do the self-management analysis. And so if you have any LP funds right now, it doesn't matter how they came in. If you have a Japan investor, you should be thinking, did I do the proper analysis for the general partner engaged with self-management? Now, the Article 63 exemption, this has been really, really famous. It was just when it was first created back in, 2008. I'll be honest, a lot of us attorneys, we kind of smiled and we thought it was a bit of a loophole because it was quite easy. Back in the day, it was just like a 3-4 page filing. We could do it in 1 or 2 days. And it was really intended for the venture capital space. It was really intended for that, but because the way they drafted it, a lot of us attorneys kind of got a bit cute and we just go, well, you just a limited partnership fund. So we just applied it to private equity, real estate, any type of fund. That was for limited partnership funds. And so at one time, I think back in its peak, there was around 6,000 to 7,000 Article 63 filers done. And as all good things, it went too far. Too many people were using it, but it wasn't really the foreign side that got in trouble. It was more on the domestic side where the Japan regulators go, okay, enough is enough. They were getting a lot of complaints about it. And so in March of 2016, the entire system was overhauled. It's not as easy as it used to be. It's not the kind of thing that we would recommend to clients lightly. There are a lot of new requirements for Article 63 filers. You have a Japan rep. You have to maintain in a website. I'm going to put an asterisk beside that because I know some people take different views about that. There's the duties on segregation of assets. I'm just saying the Article 63, there's a lot of rumors and misconceptions about it. I know some people said that the revisions of 2016 killed it. I don't think that's accurate as well. It's still around, but it has changed. It's significantly changed. It's a lot tougher, but it's definitely around. And we still see the Article 63 exemption being used by especially the private equity real estate fund space. It's being used quite often. So that's Article 63. We could talk about that forever. It's such a complex topic, but I think that is an overview of the Article 63 exemption. One of the things that we get asked a lot is about this notification of the Japan FSA, the Investment Corporate and Investment Trust filing. We're just going to call this the ITICA filing. Now, I'm going to go through this quite briefly because this is a very, very specific filing. The ITICA filing is only required for corporate and trust type funds. All right, and this is a filing that, you have a corporate fund or a trust type fund, it doesn't matter, and you want to market it in Japan, you've appointed a type 1 distributor, or maybe you have one yourself. Before a type 1 distributor can market an investment corp or investment trust in Japan, they must submit an ITICA filing, an ITICA notification to the Japan FSA. It's just one of the things that has to be done. And I do want to I'm going to jump back a bit. This also applies if you need the foreign securities firm exemption as well. So just keep that in mind. And what this is, it's about a 20 to 30 page document. It's like a translation of the key terms of the fund. And the sole purpose of this is not this notification. It's not public. Nobody ever reviews it. It's not one of those things that people get to look at, but it's the idea it allows the Japan regulator to understand what type of funds are being offered in Japan. So for example, 2 years down the road, they could just, if they hear if they have some questions about a specific fund, they can easily just look into the file and go, oh, here's a summary of the fund. So it's one of those things that if the fund is being marketed in Japan, either using the foreign securities firm exemption or using a type 1 dealer, this has to be done. And technically, a type 1 distributor is not allowed to market a fund where this ITICA notification has not been done. All right, so this again, Article 63 only deals with LP funds. This only deals with corporate and trust type funds. All right, so moving along, so you decide to come to Japan. So we just want to, in this part of the seminar, we're just going to talk, well, if you decide to come in Japan, how to do it, or what type of things that we typically see. Now, the first thing that we always get asked, and so is the key thing, we're going to come to Japan, what kind of entities should I set up? And, there's so many different types of entities, GKs or KKs, a branch. And one of the things that we always say is like, ultimately, we have listed various factors here. Like, for example, you should be aware you have to have a plan. For example, the type of activity that you might do in the future, because certain registrations require certain forms of entities. So, when you create your entity, because it's possible to change your entity later on in the future, the actual form could be a bit of a hassle, but its idea is let's try to future-proof it now. So what type of activity are you trying to do? Like the DIM and the type 1 license, which are the harder licenses to get, they have specific requirements on the type of form of the legal entity. Second thing, always tax, right? And truthfully, I'm almost tempted to say that this is the most important factor of the 4, making sure that tax works from the individual level back up to your management company. Make sure the tax works. And I think that a lot of times people find that the branches, having a branch in offshore works. From a tax perspective, I'm not qualified to advise on tax, but that's what we typically see. Next thing about the application of Japanese law, some people like branches because the head office is in their own jurisdiction and they're comfortable with the laws there. And the last one is a quirky one, so that's why I thought I specifically bring it up, because we have seen those cases where we got the tax to work. Everybody goes, we're going to do a Japan branch or a Delaware LLC, something to that. But then when they actually bring it up in the hiring, when they start talking to their Japan staff, the Japan staff goes, no, we don't like that. And it's because I'm not sure if I personally subscribe to this, but some people have a view that a branch is not as permanent. It doesn't show the same level of commitment as what we call a KK or a stock company. So they would say, we don't want to have a business card that says branch. Create a KK. And so it's one of those things is when you make this entire analysis, please talk to your Japan personnel as well, because they may have very strong views on this. All right. So moving on. All right, good. I got 15 more minutes. One of the questions that we always get is, well, we're scared. You're hearing all these stories about getting registered in Japan. It costs a lot. We don't know if it's worth it. It seems like a huge investment. So one of the things that we just wanted to briefly talk about in this specific slide was, well, what can I do if I decide not to get a license? We would view this what we sometimes call as a light touch to Japan. You think or you hear rumors that your specific strategy or product, it's going to sell like it's going to sell like crazy in Japan. So you get, you hear a lot of things, but you're not too sure. And so this is what we call the light touch. And under this entire idea is you come to Japan, you can create a KK or whatever entity you want, but you don't seek to get registered as financial instrument dealer. So what can you do then? So the 4 types of things that we typically see when people who are doing this as a purely unlicensed is number 1 is brand promotion, getting your name out there, getting your strategy out there, right? We do see that. Number 2, relationship development, right? Just getting to know the players, getting to know the allocators, getting to know the gatekeepers. Number 3, sounding of strategies, right? This always gets a bit more trickier when you start talking strategies, talking about maybe your credit strategy or your specific strategy, but you can't talk about a specific product if you talk about a specific fund. And so there's this kind of fine line when a discussion about a strategy can be deemed as a discussion about a specific fund. We've seen people who have these presentations on strategy of their fund. All they do is they cross out the word fund and they put the word strategy. Does that work? Well, it's kind of questionable, but we've seen that. It's the entire idea of, listen, marketing of a fund interest would either require a type 1 or 2 dealer, but talking about strategies, maybe that's okay. And the third one is just, listen, maybe you already have a lot of Japan investors, you're doing quite well, but a lot of Japanese investors are notorious for the level of hand-holding that they require. And they want in Japan office somebody that they can call 24/7, speak to them in Japanese. And so this is what we call this investor relations, just with existing investors. Again, we have to be quite clear. You're not allowed to engage in any of the 4 activities that we talked about initially, about distribution, asset management, or investment advice. But these type of activities are not registered activities. You're allowed to do them. And typically, if we would just see this as a test, people would just come in, and what they would do is maybe create a very small office, literally just 1 person in Japan. And they'll test it out for 1 year, as opposed to coming all in, getting all the licenses and doing all these huge commitments. It's a light touch way to just check out the Japanese market to see what future potential there is. All right? So now we're going to talk about, well, we're so-and-so. We're very comfortable. We know who we are. And when we do something, we're going to go all in. So you go, we're going to actually set up a full licensed shop in Japan. Now the question goes, which license do you get? And so I think as you can see in the PowerPoint that we just set out, it again just depends what you want to do. If you're doing fund distribution, then depending on your fund, it's the type 1 or type 2 dealer license. If you wanted to do what we call the indirect capital raise model, then that would be the DIM license. The investment advice model, this is where you would just have, perhaps you have portfolio managers in Singapore and the US, and you just want to use Japan to give investment advice. That's the IA license. The intermediary and agency license, I didn't cover this before, but it's a bit of a convoluted theory, but the IA registration, this is the same business license as investment advisory license. So there's 4 licenses. The intermediary and agency aspect is part of the IA registration. And then what it allows you to do is act as an intermediary or agent to secure investment management or investment advisory mandates for your offshore affiliates. It's a pretty complex, we have to start talking about other exemptions, but it's something I did want to raise. Again, if you just want to do pure research, that doesn't require any license. And then the last thing, client support. So if you're coming to Japan, please make sure you know what exactly you want to do in Japan. All right, on the next page, what we've done is actually, I'm not going to go through this definition bit by bit, but I just wanted to give you, this is the summary of the 4 business licenses and the requirements. And one of the things that I thought was quite interesting to note here is this has been created based on level of difficulty. So the type 1 license, this is the most difficult license. This is a full brokerage license. And if you want to sell corporate funds or unit trust funds, you need the type 1 license. It is a hard license to get. We typically say it can easily take a year, and it's not the kind of license that we would recommend quite casually. It's a tough license to get. And interestingly, the next toughest license is not the type 2 license, it's actually the DIM license. It's the DIM license would be the next hardest one to get. And it requires 5 to 7 people. It's actually, and I think the concept is it allows you to manage Japanese assets and also like pension funds. That's one of the reasons why the requirements are really high. And so the DIM license is actually the second hardest license, with the third hardest license being the type 2 dealer license, and the easiest license being the investment advisor and agency license. Now, while we have we always get asked about this, the entire headcount issue about how many people we need, so we put down general markers, like for the type 1, 6 to 8, DIM license, 5 to 7, but I want to be quite clear here. Type 2 we didn't write down, but maybe 2 to 3, right? And investment advisor maybe 2. But I do want to be quite clear. This is not an explicit requirement. There's nothing, you can look through all the laws in Japan, it's not going to say what specific number you're going to need. And depending on your business model, who your target clients are, the requirements can change. For example, if you're an investment manager, but your sole client is an affiliated company, the requirements tend to be quite low. However, if you're an investment manager, and then you say that you want to manage Japanese pension fund assets, then the requirements become quite high. So that's why it was very, very difficult for us to try to create this kind of master form, because it really changes based on your actual contemplated business model in Japan, and truthfully, it changes based on your KFB officer. There's a lot of discretion in the way that this is done, but this is a general ballpark requirements for each of the registrations. Right? So what we're going to do next is just continue on about this discussion about registering as a financial instrument dealer or 50 in Japan, and there's been a lot of discussion and a lot of correct and incorrect rumors about this. And so we just want to give what we would call a general overview of this. So first thing that we would always recommend our clients before they come to Japan, they go, okay, we're going to come to Japan. We managed to find the right talent. First thing you do before, and people get this wrong, please, before you do anything, check to see what type of subsidies or what type of exemption programs must be available to you. The Tokyo Metro government has various subsidy programs which are available to foreign asset managers coming into Japan. It's not the biggest sum of money, but it's not bad either. Like I think it's half of all your expenses capped at 70,000 US. And so it's still a significant amount, but I want to warn you, especially the FSA market entry program is one thing, but especially when you're dealing with a TMG, this is the most bureaucratic process that's humanly possible. If you get anything wrong, the specific order of the way things have to be done, the actual timing, you will lose it. And unfortunately, it even gets worse because of the TMG program, it's like a moving goalpost. Like it has been changing all the time. Unfortunately, it's been changing in the worst direction. It's getting tougher and tougher to get this. But so it's one of those things, if you are coming to Japan, before you do anything, please check what might be available to you, because if you get the order wrong, you will just be disqualified and you just wasted a lot of money. So that's the first thing. Number two is then what happens after you've done the FSA meeting where you kind of dug your intention, and then you checked out all the programs, then you'd have this initial meeting with the Japan FSA where you kind of announce your intention to go, hi there, we're so-and-so, we would like to come into Japan to get this specific license. But one of the things I do want to be clear right now is this process has now changed quite a bit now with entire COVID. Before, you would always have to come in and do this kind of introductory meeting. Now they're like, well, no, thank you very much. We can do this by paper. So this step number two, we don't think is as necessary now. If anything, they're telling you not to come in, and they will want to do most of the application by paper. They don't need to see you, all right? So that's step two. So what is the application process itself? The application process itself, we kind of divided in two specific stages. The first stage that we listed here is really this pre-submission stage. And I suspect it's quite different from most jurisdictions. And it's really this entire concept where you have to prepare all these documentation, application documents. All of this has to be done in Japanese, and you would submit it to Japanese regulators. It talks about your business plan, your target clients, yada, yada. It just says this entire business plan. And then they send comments back. You revise your document based on those comments, you resubmit. After maybe a week or so, they send the comments back. And you have this process of really where you're just sending these comments back and forth, until the documentations and all the application documents are in a form that it's acceptable to Japan regulator. And depending on the license, and not only the license, it depends on the actual KFB officer who's in charge of your registration. This could easily take 4 months. It can go much longer depending on the type of your license. Yes, we've heard of urban legends of, like Legal in General doing that in 10 weeks. We kind of have our suspicions on that, but then we also heard these horror stories of people doing it in 2 years. No, that's a bit much too. So I don't think that's reasonable either. So what we're trying to say is generally, depending on your license, it could take 4 to 6 months, this entire pre-submission process. But it's just really how quickly you can get the documents into a stage that is acceptable for regulators. Once you make your formal submission, this is actually quite nothing to do. This is just the documents are submitted to the KFB offices, and it's just really reviewed by them. And after 2 months, you will get your license. This is set in stone. After 2 months, you will get your license. It's usually done in usually 6 weeks, but the fact is after the formal submission, as a matter of fact, within 2 months, you will have your license. However, one of the things that we always want to warn clients, no, that's not it. That's not the end of the story, because please make sure that you don't have to be a member or you don't have to join certain self-regulatory bodies. For example, like you have, the JSTA, or you have the Japan Securities, this is for type 1 dealers, or you have to join the Japan Investment Advisors Association. So it's one of those things you have to plan it properly. Right? This doesn't end when you get your license. You can't start trading just because you need to complete your registration at the relevant SRO. All right, so moving along, I'm quite mindful of time, but I actually think the timing is going quite well right now. So last kind of things that we want to give you some practical advice really on things to consider when you come to Japan is, if you're thinking about a registration, because we don't like license pushing, it frustrates me. That's the worst thing that I hate the most is license pushing, where you're being told to get a license that you don't really need. So please be sure, what is the purpose of the registration that you're looking for? Does it make sense? Do you really need this? Is there an appetite for this? Are there any other ways? Like we talked about some exemptions already, like the foreign securities firm exemption, the article security. Is there other ways you can do this? Like as a law firm, yeah, of course we'd like to try to push a licensing, but that's not what we want to do. We don't want to push something that you don't need. So please consider this. Other kind of things that I'm going to end off on talking about is, I can't speak to other jurisdictions, but the key gating item, pretty much every single time in all the registrations, is the compliance officer, right? Except for the investment advisory officer. The investment advisory registration, the type 1, the type 2, the DIM, they all require a compliance officer. So compliance officers are quite hard to find in Japan, and your registration will not even start. If you don't have a compliance officer ready to go, it just makes everything very difficult. So one of the things that we always talk about when people are saying, we're going to come to Japan, our first question is, have you found your compliance officer? So just please be aware in Japan. I'm not a headhunter, but my concept is that there's a very limited pool with respect to compliance officers, especially compliance officers who are who have international experience, have the ability of language. So please keep that in mind. And all right, so that's really about it. I do apologize for just burning through the last couple of pages. What we're going to do now is we're going to move to the Q&A segment, and we're going to begin to answer the questions posed as much as possible. And I do apologize if I don't get through to any of your questions. You can feel free to email us those questions. All right, so we got the first question here is there a reverse inquiry exemption? Are there restrictions on marketing to Japanese investor at a location outside of Japan? Wow, this is one of a I don't know who wrote, Mr. Bennett Lee. This is a very, you've hit a very good question. So reverse marketing, and it's one of those, it's like Voldemort. It's like a taboo topic here in Japan. It's very hard to find any written material about it. But reverse marketing, number one, there is no formal exemption. Like I know in the UK, there's actually a reverse inquiry exempt, like it's actually a statutory, but in Japan, there is no such thing. But instead, in Japan, there has been a practice of using the reverse, we call it more reverse inquiry, reverse marketing, but we like the word reverse inquiry, where there are a lot of fact patterns where people will use the reverse inquiry model to raise capital in Japan. And this entire idea that's based on the idea that, listen, we did not actively market these interests in Japan. Instead, what happens is that we are who we are, and Japanese investors came to us. And so we never engaged in soliciting or marketing, and that's what the entire concept of reverse marketing is. Reverse marketing is one of those things that it does happen. I'd be very being disingenuous to saying it doesn't happen, but I think one of the things is be careful with reverse marketing. And we don't know anybody who's been sanctioned by it, so I just want to just say that right now. But at the same time, the thing with the reverse of marketing, it's not just the regulator. The only thing we always say to all clients is make sure that you and the investor are on the same page when you use reverse of marketing. There's nothing more embarrassing or nothing more confusing when the Japan investor thought you were marketing using the foreign securities firm exemption or some other type of theory, or they thought you were properly registered when you were using the reverse inquiry model. The reason why this is quite relevant here in Japan is, let's just say if the Japan regulator, they were getting very draconian and they were going after people who were engaged in unlicensed marketing, like they should have had a type 1 or type 2, but they didn't. The fact of the matter is, it's very not so likely that the Japan FSA is going to jump on a plane and fly to the US with the US SEC or the Hong Kong or Singapore to go after these people. It's, it's theory, it's possible, but the Japan regulator has a tendency to hit the people that are closest to them. So what they did is I think about 6-7 years ago, they hit the Japan investors. So instead of going after the market, the managers, they would go after the Japan investors, go, you did not display proper due diligence or proper regulatory compliance by subscribing to a fund that was not properly marketed in Japan. So you can see how the Japanese regulators operate. So this entire discussion about reverse marketing, people still do it. It'd be absolutely incorrect not to say that, but be smart about it and make sure that your investors know this as well. Because some investors, I think, for example, we heard rumors that certain divisions of GPIS or Japan Post will not accept the reverse inquiry model. And the second thing, I guess, when I said be smart about it is, we can understand reverse marketing happening a couple of times a year, but if I hear that a manager has 30 Japanese investors in a given year under reverse marketing, I would be kind of nervous, because having 20 to 30 investors, that seems like there's a systematic intent to market the fund using reverse inquiry, and so I think that's quite dangerous. So the second part of that question, are there restrictions on marketing to Japanese investors at a location outside of Japan? Well, this is what we've called, previously it was called the offshore subscription model. I'm not too sure how it really worked. I got the theory of, I know what the theory is. Okay, well, hi there, listen, because we don't have a license to market in Japan, why don't you make a trip to Hong Kong or Singapore and we'll talk to you then. Yeah, it's not, in theory, I get it, but it's the kind of model, this has been shut down in other cases. And what I mean by that shutdown is, we've seen this in the insurance space. And I think the main thing with this offshore subscription model, we hear people, oh, well, make sure you sign all the documents outside of Japan, yada, yada, yada. But at the end of the day, if there's an intention, and if there's, God forbid, that there's some kind of emails or paper trail that kind of documents an intention of the manager and the investor to circumvent the application of Japanese law just by taking a trip offshore, they will get, Japan is a principle-based system. There's a good chance they will get you for this. We saw this a lot in the entire space of insurance. Where a lot of companies are trying to fly people, Japanese nationals outside of Japan to get insurance products are better outside of Japan, but no, the Japanese regulators, no, you can't do that, right? So I hope that answers that question. We have another question from another autonomous. How about a fund that's structured as a Singapore Incorporated Limited Liability Company with direct capital raising from corporations in Japan? So if the fund manager has, okay, okay, well, this is a very, very specific question, but I will try to do the analysis very quickly. So the fund is, because it's a Singapore LLC, most likely this will be deemed as a paragraph 2 security. Now, unfortunately, with paragraph 2 securities, typically I go use Article 63, but using Article 63 with LLCs is questionable at best. It's something that we don't see. It's something that you can challenge, but the default rule is your fund interest will be deemed as paragraph 2 securities, and in order to market this, you probably have to use the type 2 dealer. You'd either be registered yourself or you'd have to appoint a type 2 dealer. Unfortunately, your license that you have in Singapore won't specifically help you in your ability to market the fund. However, the ITIC fund is not required. Because these interests are paragraph 2 securities, you don't need to, because the type that you don't have to do ITIC fund. I think one of the things, and I do apologize, I'm not overly familiar with the Singapore LLC structure. That's why I'm kind of, we don't see it as much, but I guess one of the things that you could explore with that, and I do kind of ask you to send an email, we can follow up on this, is the ability to engage in self-offering, self-marketing because of the LLC structure. Question number 3, another question on reverse marketing. Our thoughts on that, I think we've already answered that. Oh, here's an interesting question. Why do Japanese investors always prefer a trust fund? All right, so this entire thing is, before I get into this, I have to really be, this is a very much a tax-driven question, and I'm not tax qualified, so disclaimer here. But yes, this is one of those things that you will always see. Japan investors always asking, do you have a trust fund? Do you have a trust fund? We love your fund. Do you have a trust fund? Where does this come in? Why does it, where's this all coming from? First of all, the entire preference for a trust fund, it only applies to Japanese taxable investors. Doesn't apply to the pension funds. So pension funds will be investing in anything and everything. LPs, corps, trusts, they don't care. But for Japanese taxable investors, the banks, the insurance companies, the general companies, individuals, it's most likely that they will be seeking a trust fund, because there's something, again, I'm not a tax attorney, but I will explain it. There's something in Japan called the anti-tax haven rules of Japan. With respect to a fund that hits either of the following requirements. Number 1, a single Japan investor has more than 10% of the total shares of the fund, or total interest of the fund, or 50% or more of the total subscribers to the fund are Japanese. If either of these 2 requirements are met, the fund in question is hit by the Japan anti-tax haven rule. What does that mean? And this is more relevant only for the hedge funds or things that have solid NAVs. Say if you have a fund, it starts at 100. At the end of the year, it goes to 140. Even though if I'm the investor and I put in that 100, I'm the Japan investor, even though I have not even redeemed, I haven't even taken the fund out, and none of my money in it, I get deemed, it's deemed distribution. It's like I get taxed on 40. Even though I did nothing, the money was still stuck there. A lot of Japanese investors obviously don't like this. So if you get hit by the anti-tax haven rules, you get hit by deemed distributions. And the only one type of fund that is exempt from that is the trust fund. I just want to be quite clear. It's not just the trust fund. It has to be a trust fund that qualifies as a securities investment trust. So people get this wrong, and if you create a trust fund and it's not a securities investment trust, you just wasted a lot of time. So please be careful that when you do create this trust fund to take in this Japanese, most likely a bank or an insurance company, make sure that that trust fund is also a securities investment trust. All right, next question. Oh, we have a lot more questions than I thought. We at Cayman LP raised capital from 2 permitted investors in Japan. Is it easier for me to use Article 58 or the Article 63 exemption? So I'm assuming you're talking about the foreign securities firm exemption. I would have thought that the Article 63 exemption would have been easier for you because it allows you to come into Japan. People are more familiar with it. And if you have a Cayman LP, it's kind of perfect for that case. The foreign securities firm exemption, I guess, is possible. But again, I think a lot of that, it's just your ability to come to Japan. And I guess the second thing, it goes really back to my point, is you said you were Cayman LP and you're raising capital from Japan LP investors. The fact of the matter is, it goes back to my point, is it doesn't matter how you even market the fund. If you have a Japan investor in the fund anyways, it's quite possible the general partner you have to rely on Article 63 anyways. It's the same filing. So what I'm trying to say is, since you're going to have to do the Article 63 analysis anyways with respect to Japanese investors, with the self-management analysis, it makes more sense. It's just probably just bite the bullet and do it for the marketing as well, because it's the same filing. Okay. Moving on. Regarding reverse inquiry, if a fund manager uses an introducer, wouldn't that 100% cover the fund manager? On this question, I guess my first question is, what is an introducer? If the concept of the introducer is being a type 1 dealer or type 2 dealer, yeah. We wouldn't even call that reverse marketing. You've privately placed your fund in Japan. There's no reverse marketing. If you start talking about an introducer as being the cap raising function of a prime broker, that's a more difficult topic that I'm not sure how comfortable I feel talking about it right now. But yes, I guess there's this kind of argument that says that, listen, if you're getting an introduction from a cap intro place and you didn't pay that cap intro provider, there could be an argument for reverse marketing. That's a very fact-specific question, and it's probably one that I'd probably prefer to discuss offline. Can I obtain investment advisory license while working in a Singapore-based financial institution? The answer is yes. The investment advisory license, while the Japan regulator won't be overly excited about it, the IA license is the one license that you can get outside of Japan. I believe Singapore, our good friends at Cambridge Associated, that's an offshore IA, I can talk about it as public. So you can definitely get the IA license outside of Japan. Historically, you could get the type 2 outside of Japan. You can't do that anymore, but you can definitely get the IA license. Next question. All right, 2 more. Would a segregated portfolio company or Singapore, oh, this one. So would a segregated portfolio company or Singapore incorporated via the Singapore structure, CCAP, be required to file an ITI notification on marketing? We would say yes. Our understanding of this new Singapore corporate CCAP, at the end of the day, it's a corporate fund. We understand it's like a segregated portfolio. You can create sub-portfolio unders, but at the end of the day, it's a corporate fund that issues shares. Most likely, it would be deemed as a paragraph 1 securities. You would require a type 1 dealer, and you would have to do the ITI filing. Oh, last question's a doozy. Can you share your thoughts on the trust company license? This one's a kind of an interesting license because I think the trust company license, I'm trying to get a sense of which form you're talking about. We see what we call the investment trust company license. We call this the ITM license. And then we see the general, and I'm not sure which, oh, there you go. Oh, wait, that's moving too quickly. Investment type trust. Okay, so yeah, so I'm assuming that this is the same person. So I think you've made clear it's the ITM license. The ITM license is a subset of the DIM license. And under the DIM license, there are 2 subsets. So the first one is called the Pro DIM license. This is what we call the investment management license light. It allows you to get a DIM license with lesser requirements. It's a bit more easy. The ITM license is the flip side of that. It's a harder version of the DIM license because it allows you to manage onshore domestic trust funds. There's this entire question of, does it apply to offshore trust funds? But we can push that aside. But the key thing is, if you wanted to manage a domestic trust fund, you would need the ITM license. It's fairly difficult to get. And the only reason I would anticipate you wanting to get this is we typically see domestic trust funds because you're probably considering a public offering in Japan. Because that's where we see the trust, the ITM license. Like all public offerings, usually for onshore structures, it's always a domestic investment trust. And to manage a domestic investment trust, you need the ITM license. All right, listen, I do apologize. There's so many, a bit more questions than anticipated, and I wish I could go through with more details with everyone, but please, I think this is a great opportunity. Just feel free to send me these questions by emails. We're happy to have a call or clarify these questions. Without bragging too much, this is really our bread and butter. We see pretty much this kind of stuff all the day, so we feel quite confident that we can really kind of give you both legal and practical advice on what we see in the market space in this area. And so I know that's time, and I know everybody's busy. For those who are in Japan, I know we're looking at a 4-day weekend, but I want to take this moment to thank everybody for their time. I know you're very busy, and please ask us any other questions, and thank you very much for your participation. Have a good day. Suppose we hit something? I hope I'm not.